Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
I really hope everybody's safe and healthy. Well, first, I would like to thank Professor Leonardo Nemer for the invitation in this great event. The winter course organized by Sdgs is always a wonderful opportunity for those who love international law, as I do. Well, today, I have the honor to introduce one of the greatest researchers in our field. She's an international law professor at the University of Geneva. She's a recognized practitioner for her role as an expert and advisor to states, non-state entities, and international organizations, such as the UN, the World Bank, and the World Trade Organization. She's an arbitrator and counsel in many dispute settlement fora, such as the International Court of Justice and the Court of Arbitration for Sports. I could go on, but I think it's better if we go ahead for the part that we'll listen to what she has to say for us today. It will be a great opportunity for us all. And I may say, especially for me, we've been studying her work on freshwater in international law in our study group back at UFLA, and we've been looking forward to learning from her lecture. Oh, and just to remember, you can all send your questions, and we will have time for that at the end. So, without further ado, I present Professor Laurence Boisson de Chazou.
Good afternoon. Thank you very much, Professor Diniz, for this presentation. I'd like to say that I would have loved to be in Brazil at that time of the year. And we met with Professor Diniz some time ago when I first came to the Sdgs of Brazil. I would also like to thank Professor Leonardo Nemer for his invitation and for what he has accomplished in Brazil and with respect to the development of the knowledge of international law. And also a special thank to Paula Neves, because without her, we would not be here today, me in my office in Geneva and you sitting in different parts of Brazil. So we are going to be speaking about access to water. And Paula told me that you have received the PowerPoint that I sent, but I'm going to be sharing it with you. So I will try to be... So we will have this PowerPoint. I'm going to be, that's great. Thanks. So you have the title, Access to Water in International Law. What we will be doing this afternoon is that I will introduce the topic. We will be then speaking about instruments and principles and give you some examples of water disputes and then look at the links between water and environmental protection and water and human rights. So let's start with the introduction. And Professor Diniz was saying that it's a topic of great interest to the group of research in Brazil. In fact, it's interesting because water is gaining importance for many reasons that we will be discussing. But in fact, water has always been in the field of international law for one reason or another one. And really special attention should be given to international water law at the beginning of the 19th century. And why is it so? Why do I stress the 19th century? Because it was at the time when navigation was important, and it's mostly through navigation that the body of international law related to water gained some shaping. Now, what is interesting is that in the course of the 19th century, navigation was an important use, and international developed in accordance with to regulate this use and think about your own region and what was going on with the Amazon River, for example. In Europe, it was the Rhine, it was the Danube, and other rivers. Now, when we speak also about international water law in the 19th century, we should also think about international water courses and boundaries, because a lot of the boundaries that we're discussing today were sort of designed and identified in accordance, in reference to some international water courses. In the course of the 20th century, in the 19th century, people were starting to speak about fishing activities. But so 19th century important because it's an interstate perspective, it's a shaping of the rule of law in accordance with certain users, but it's mostly in the course of the 20th century that we're going to see an increasing number of users of water courses, and so a sort of diversification of the rule of law. And a lot that we will be discussing took place in the second part of the 20th century, with users such as agricultural users, industrial users, or environmental users. Now, something that is important is that when it was shaped and in the course of the 20th century, the focus was really on the interstate perspective, the relationship between one riparian state to another riparian state. But what we have seen at the end of the 20th centuries and in the beginning of the 21st century, that more and more there's been an attention from the field of human rights, from the field of environmental law, to look at how the states were sort of regulating access to water to the people resulting from their own jurisdiction. And in this context, we will see that in the last part of this presentation, we have seen the shaping of a new human right, which is the human right to water, access to water and sanitation. So that's the introduction, and I will try to show you this sort of different levels of regulation. Now, if we look at the instruments and principles, what are they? And there, I think it's interesting for us international lawyers. You will see that we have instruments at what I call the universal level. When I speak of universal level, I mean it's instruments which are open to all member states of the international community from all regions of the world. But you also have regional instruments, and we're going to see that we also have what I call in international water law terms, local instruments, basin instruments, regulating specific water courses. So let's start with the universal dimension. We have three types of instruments which are important and instruments of reference. The first one is the 1997 United Nations Convention on the Non-Navigational Uses of International Watercourses. This convention, I'm going to call it the UN Convention, is the result of the work of the International Law Commission. And I know that you had several professors who were former members of the International Commission and who worked on this convention. And this is a convention which is interesting because it shows that it originates at the early 70s, when at the General Assembly, the states realized that there was a plurality of users, but it was very difficult to see what should be the hierarchy between users and which state should have access to water and what should be the principles. So the General Assembly asked the International Law Commission to work on draft articles in relation to non-navigational users of international watercourses. Non-navigational users, because remember, I said that navigations had been sort of regulated, shaped, and in the course of the 19th, 20th century. But there was an issue about the other users. Now, the International Law Commission worked for about 25 years on this convention. There was then a working group at the General Assembly, which was convened, and the working group adopted the convention in 1997, and it entered into force in 2014. It's not really widely ratified. You have about, if I'm not wrong, 35 or 36 parties to the convention. I'm stressing that all these elements because there is a purpose behind that. In fact, if you look at the works of the International Commission, you will see that you can see in practice that states are very reluctant to commit when it comes to the sharing of water or when it comes to limiting their sovereignty with respect to access to water. So it took some time, but I think that the result of the work of the International Commission was very important. And what the working group of the General Assembly did was also important. And the outcome, in fact, is an instrument of reference. And even though it's not really widely ratified, it's representing in great parts the status of customary international law. So it's what I'm used to call the language, the common language that we have when we speak about the regulation of international watercourses. I'll come back to this instrument. The second instrument that I would like to refer to is the 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes, which was adopted under the aegis of the Economic Commission of the United Nations. So you're going to say, but this is a regional instrument. And you will be right in saying that at the origin, it was a regional instrument, which entered into force in 1996. But since the early 2013, it has been amended. The amendment had entered into force, and now it's accessible. It's open to all states of the international community. I'm stressing that because there are certain Latin American countries which are discussing, becoming interested in becoming a party to this convention. And you already have some African countries which have become parties to this convention, and I'd like to name Chad and Senegal. So those two instruments are what I call the universal instruments. The third instrument that is important, and it's important, for example, for Brazil, for Argentina, is an instrument which is called the ILC draft articles on the law of transboundary aquifers. Okay, transboundary aquifers. I'd say that this is a topic which is not, which had not really kept the attention, was not on the agenda of the international community for a long time. But most of the water that we're using in all regions of the world are coming from aquifers. Okay, so states and the international community have accepted that there should be some clarification about the rules applicable to transboundary aquifers, and think about the agreement on the Guarani aquifer in your region, which is codifying a lot of the principles as contained in the ILC draft articles. So those are the universal instruments. I'll come back to that, but in fact, we can call them framework instruments, and I'll come back to the reason for that. Regional instruments, I will spend less time, but in certain regions of the world, you have some regional instruments, and I'm thinking of the southern part of Africa with the SADC revised protocol on shared watercourses. I'm also thinking of the Economic Commission for Europe, and also at the level of the European Union, you have some, you have a few instruments dealing with regional waters. But most of the instruments, when we speak about international water law, most of the instruments are what we call basin agreements. Basin agreements in a way that they are binding on riparian states to a watercourse. So there, in the PowerPoint, I have given you a few examples of these instruments, trying to put examples from the different regions of the world. So you see that you have this practice everywhere. It doesn't mean that all watercourses of the world are regulated by international watercourses. You still have what I call orphans, international watercourses, which are not regulated by a specific instrument. But that being said, you have a large number of bilateral, plurilateral, multilateral instruments regulating specific watercourses. And what you see when you look at these specific instruments is that there is a great diversity among these instruments, because, and this I think explains the reluctancy of states to commit at the universal level, watercourses are different one from each other. And the states have always been keen to reflect these specificities, these particularities. But you also have to take into account that although international law speaks about equality, equal access for all states, all riparian states, the geopolitics are there. And you can also have relationships between states which are not equal from a political viewpoint, and you're going to have a reflection of this political imbalance in the instrument. So I'm stressing this element because you will see, if you're interested in this topic, that there are quite many discussions about sort of the amendment of some of the instruments, about the adjustment of some of the instruments in light of the principles of international law and so on. But that explains also why we speak about framework, because the 97 convention, when it was negotiated, was for the members of the International Commission, for them it was only the idea that they would give a broad framework which would contain pillars, which would be important to be reflected in basin agreements. But then it was always considered that the state should have the choice, should have the margin of discretion for developing, negotiating specific watercourses agreements. And for us, from a perspective of international law, I'm going back to the previous slide. It's interesting because we have dynamics between the universal, regional, and the basin level. When the ILC was working, the ILC was looking at the basin practices, okay, and the regional practices, just to codify, to be codified at the universal level. But when they were working on the framework of the Universal Convention, they were also trying to say, look, at the basin level, they should take into account what we are negotiating, so to modernize their treaties. So you have dynamics which are interesting from the viewpoint of international law. Now, the 97 Convention is also an interesting convention because it doesn't have any institutions, not a secretariat, not a convention, conference of the parties, or any other mechanism. And it makes it a bit a lonely, I would say, a lonely cowboy, because it doesn't have sort of a community that can sort of support it and develop it. And I think that this is also something that we international lawyers should be thinking about, is how to make the 97 UN Convention more well-known and more widespread in practice. Now, I told you, the importance of the 97 Convention is that it's a framework, but it's a framework telling states, look, there are important pillars that need to be reflected in each basin agreement. So for me, as far as I'm concerned, there are four main pillars. The first pillar is the pillar relating to the sharing of water and benefits. I'll come back to that. The second pillar is related to the obligation to cooperate when you share a water course. The third pillar is in relation to the protection of the environment. And the fourth pillar is in relation to the protection of human needs and public participation. Okay. And then, in order to make sure that these pillars are going to function well, will be well established, you need prevention and means for settling disputes. So let's go back to the first pillar, the water sharing. And it's not just sharing water in terms of quantity, but it's also sharing water in terms of benefits, meaning that a riparian state might have access to water and might have mountains and so on. So this riparian state is going to be able to develop energy, and the benefit from this development should be shared or could be shared with the other riparian states. So it's not just, as it was traditionally seen and analyzed, an issue of amount of water. It's an issue of how to use this water and how the states can have access to this water and benefits. There are two principles: the principle of equitable and reasonable utilization, and the obligation not to cause significant damage. Those principles have been the cause of disputes between states. I will give you one example when we come back, when we look at the practice. But think of certain regions of the world, and you will think, for example, a magnificent watercourse, which is the Nile River, and think about the position of Egypt. For the time being, they're quite. There are a lot of discussions with Ethiopia and Sudan. Egypt is saying, I rely on the water. So the main principle for me is the obligation not to cause significant damage. Now, equitable and reasonable utilization, think of my country, Switzerland. It's the source of many international rivers, and they're saying, yes, we have to take care of this river, but we should be able to utilize it in a reasonable manner, and everybody should have a say on and have access to the water. Now, you can go back to the 97 Convention. I think that these two principles are fundamental principles of international law. The big problem in international law is that there is no priority, I think, between these two principles. And then it's for the riparian states to agree on the right formula so that they all are going to benefit from the water course. And that means that in certain situations, this might cause a situation of veto power for some countries. And this is where we international lawyers should be thinking about ways to prevent disputes or ways to resolve these disputes. And we can come back to that in the discussion. Second pillar, it's the obligation to cooperate. In this context, cooperation means that, and you might have seen that in the case law of courts and tribunals, it's, yes, you have access to water. Yes, you are bound by the principle of equitable and reasonable utilization or the obligation not to cause significant damage. But to make sure that these principles are going to be complied with, when you are sort of thinking about a project that you want to develop, you should notify the information about this project to the other riparian states. So it's the obligation of notification and consultation with the other riparian states. And we will see a case where that, very soon we'll see a case where this principle was at the core of a dispute between two riparian states. Obligation of cooperation is not only notification, it's also exchange of data. And this, I think, is something to be also kept in mind, is that when you have the data about a water course, you are going to have means for regulating it the best you can. Now, states are reluctant to produce this data. And in all regions of the world, you need trust among the riparian states. Often you don't have this trust, or some states are going to consider that, in fact, these data are so sensitive, they are pertaining to what we call the defense issue, sovereignty issue, and so on. So I think there's a lot of work to be done with respect to increasing cooperation with respect to the exchange of data. Now, the other component of the duty of cooperation is in relation to river commissions and so on. And there, I think that is also something which is peculiar to water courses. But if you really want an instrument to be well implemented, you need institutions. You need institutions. And these institutions, in some regions of the world, they're well developed. In other regions of the world, they are quite fragile. And I think we also need to be thinking about how to strengthen these river commissions. Then third pillar, the protection of the environment. I'm not going to say much because we're going to be discussing it later on, but it's quite recent. In fact, it's, to speak about Brazil, it's really at the time of the Rio Conference on Environment and Development in '92 that the links were forged between water protection and the environmental protection. And if you look at Agenda 21, you will see that there is an important chapter dedicated to the protection of fresh water. And you will see when we look at these instruments that if you don't have a good protection of the environment, you're not going to have a sound protection of water. Okay. So there is a very important link to be established between fresh water and environment. Fourth pillar, and we will speak about it too, it's protection of human needs and public participation. What I'd like to say is that the 97 Convention, I think, doesn't say enough about public participation and human needs. There are a few provisions, but I think it's not sufficiently developed. What I consider is, in fact, that the emergence of the right to water, the emergence of the right to a clean environment are ways to interpret the 97 Convention in an evolutive manner that makes the people, the human needs, important in the context of the regulation of international water courses. Lastly, what does the Convention say about prevention and dispute settlement? Not much. There is at least a fact-finding commission which is accessible to all parties at the request of only one party. But when we speak about fact-finding, the outcome is non-binding. Okay? So it's a mechanism which can help to solve a dispute, but it's not going to solve it as it is if you don't have the agreement of both all the riparian states. Otherwise, it refers to diplomatic means and judicial means, but you need the consent of states. And I think this is also a witness of international water law, and we can come back to that in the discussion. Now, examples drawn from practice, so that you understand how these principles can find place. I'm going to be very brief. You have the PowerPoint, so you can go back to the PowerPoint and look at some of the slides. But we have two important cases that have been sort of dealt with by the International Court of Justice. It's the Gapchikovo-Najimaros project case and the pulp mills on the River Uruguay case. We have a pending case, which is opposing Chile to Bolivia, the Silala case. And so those are the cases of the contemporary cases of the International Court of Justice. But it's interesting to see that, in fact, for a long time, courts and tribunals have been dealing with water disputes. And if you look at the case law of the Permanent Court of International Justice, you will see that there have been quite important cases decided by the ancestor of the International Court of Justice. I'm speaking of the International Court of Justice, but you also, if you want to look at practice, you can also refer to arbitral decisions such as the Lake Lanu case or the Kishangaga case, where you have also some important statements about the principles of international water law. But let's look at these two cases as examples. Gapchikovo-Najimaros case, it opposed Hungary to Slovakia. There was a treaty, a bilateral treaty. There were a political situation which changed in this region of the world, and Hungary suspended the works and said that it was no more bound by the prescriptions of the treaty. Hungary at some point also denounced the treaty. Czechoslovakia said, and then Slovakia, because of the appearance of these two states, Czechoslovakia said, this treaty is still binding on the two states, and if you're not doing what you're supposed to do, I'm going to deviate part of the Danube so that to produce energy. This case went before the International Court of Justice. And I think it's interesting, and it's a very important case for many reasons, for the law of treaties, for state responsibility issues, for the law of environment, but also for fresh water. There, in the context of this dispute, Hungary to say that it was willing to suspend the treaty, the bilateral treaty, and that it wanted to denounce the treaty, said, if we go ahead with this project, there will be pollution, there will be problems with the biodiversity, and there will also be a problem of pollution of the aquifer, which is feeding the city of Budapest. So there was an issue about the protection of the environment, but also pollution that would cause damages to sources of water. Czechoslovakia was saying it's not the case, and so on. There were environment impact assessments which were made. In the context of this dispute, the court didn't really enter into the sort of scientific issues in relation to the case. The court decided that the treaty was still binding on the two states, but they should renegotiate the provisions relating to the protection of the environment. With respect to the law, the 97 Convention and to international water law, what is interesting is that, remember, Czechoslovakia deviated water. It deviated about 85% of the water of the Danube to feed its project, and then it said, but I'm restituting this water. Hungary said, you're not entitled to do that. And then Slovakia said, I'm entitled to do that for different reasons. Subsidiarily, it's a countermeasure to what you're doing. You're suspending, you've denounced the treaty, so it's a countermeasure. And there, the court said something interesting, because the court said it can't be a legal countermeasure because it's disproportionate, okay? And the condition of proportionality is important. And then how did it justify this issue of disproportionate use? It referred to the principle of equitable and reasonable use of the water resources of the Danube. And it said, you have not respected this principle, so in fact, it reveals that there is disproportion, and that means that the countermeasure is not legal. So, environmental protection and the importance given to the principle of equitable and reasonable share of a water course. Some have said, look, the court has said that this is the most important principle. I don't think the court has said so. And I think the court took this principle, but the court also didn't deny explicitly that the obligation not to cause a significant damage was also a principle of international law to be respected. The other dispute that is interesting for us is the dispute which opposed Argentina to Uruguay. And there it was about the construction of pulp mills on the riverbank of the river Uruguay, on the side of Uruguay. There is a treaty between the two states, between Argentina and Uruguay, a treaty which was adopted in 1975. Argentina brought the case before the court because it said Uruguay should have notified these projects to the commission established in the context of the 1975 statute. Uruguay should have notified this project and we should have been able to assess the risk of environmental degradation. Uruguay didn't do it. Uruguay is violating some of the provisions of the treaty. So we are entitled to go before the court, and remember that there is a compromissory provision which allowed Argentina to bring this case before the International Court of Justice. Now for us, in the context of this class, what is very interesting is that it was an occasion for the court to look at the principles applicable with respect to the regulation of an international water course. So it looked at the 75 convention, the tree statute, but it also sort of interpreted this statute in light of principles of contemporary international law. So rational and optimal utilization, Article 5 of the 97 Convention. It gave a lot of emphasis to prior notification and information, okay? And there, I'd like to stop a bit on this principle because there, Argentina was saying, you know what, Uruguay, when you provide this information, you should have provided an environment impact assessment report. You should have made this impact assessment in accordance with the international practices and good practices. And we should have been able to assess the potential damages to the environment. So for the first time, and if you're interested in these issues, you can look at the decision of the court. For the first time, the court said, at the time of the notification that a riparian is committed to do, the riparian state should produce a report, an environment impact assessment report. Then Argentina said, but when you're notifying, when you're producing this environment impact assessment, that means that you should also be consulting the riparian populations. Uruguay said, but this is not an obligation, and we've done it. Argentina said, no, you have to consult the population at the time of the elaboration of the terms of reference for the environment impact assessment, and when the report has been finalized, so to have the reactions of the populations. The court, I think, was not very good with respect to the consultation of the riparian populations because it said quite bluntly that there was no requirement in international law. And I think that the court states that too quickly because, in fact, human rights is supporting this obligation to consult the populations which might be affected by a project. So, you see, those two cases are interesting for us because they are showing us how these principles can be sort of put in action and how courts and tribunals, how they take their decisions. Now, if we move a bit, so I have spoken in terms of what are the principles of international water law. And in a way, I have spoken about what I could call classical international law in relation to international water law, the shaping of the norms in the 19th, 20th century, and this sort of interstate perspective, which is quite prevalent in the context of international water law. But what is interesting is that with the development of international environmental law, we've seen that, in fact, new types of instruments have helped to better protect fresh waters. And you could refer to the principles of international environmental law as enshrined in the Rio Declaration of Environment and Development. We can put that aside today. But I think special notice should be given to the multilateral environmental agreements because, as I'm going to try to show, a lot of them are, in fact, contributing to the better protection of fresh waters. So let's look at some examples, and I'd like to refer to one of the first environmental convention dealing with freshwater issues, which is the 1971 Convention on Wetlands of International Importance, which is also called the Ramsar Convention. Interestingly, it's a convention which focused primarily on the habitat for avian fauna. So it was for specific species. The people who drafted the convention, who negotiated the convention, thought we have to protect the habitats of these species. Now, over time, what we've realized is that we, in the Western world, but in other regions of the world, we're destroying wetlands. We're destroying wetlands because of urbanization, because of industrialization, and so on. And what was realized is that when we are destroying the wetlands, we're destroying very important sources of fresh waters. And so there was a realization in the 90s and thereafter that wetlands should be protected because they are habitats for species, and that's very important, but also because they are sources of water for a lot of people in the world. And the example that is often given, but I think it's very explicit because a lot of you have already gone to New York, but a lot of the water that you're drinking in New York is coming from a wetland, which is located in the state of New York, in the northern part of the state of New York. So what with this example, what I want to show is that, in fact, wetlands are natural ways for filtering water and preserving water, and that we, human beings, we're using this water for domestic uses. So they should be protected, and they're, I think it's also, when we speak of wetlands, it's not just the access to water for domestic users, but it's also wetlands are functioning as sponges. They can help regulate floods and so on. So there are a lot of functions, environmental services, as we could name them, which are important for protecting and regulating fresh waters. And often, the Secretariat of the Wetland Convention of the Ramsar Convention is located not too far from Geneva. And we often call the Ramsar Convention the third universal convention dealing with fresh waters. Now, other convention dealing with fresh water, the UNESCO Convention, the World Heritage Convention of 1972, look at the list of, it's a convention which is protecting sites of international importance. States are presenting sites and the Commission is selecting them. And there you will see that among the sites which are protected by the UNESCO Convention, there are a lot of fresh water sites. And so that's an additional means for protecting fresh water. And then comes the Convention on Biological Diversity, which was adopted at Rio in 92. And this is a very important convention for many reasons. It's protecting ecosystems, it's protecting species, and it's protecting also the genetic patrimony. But with respect to ecosystems, and you can look at reports and so on, you will see that there is more and more emphasis which is posed, which is put on the protection of inland water ecosystems, and the taking into account that rivers, international water courses, in fact, are important ecosystems. And if you don't protect the water courses, you're destroying the environment, which is in relation to these water courses. So the Convention on Biological Diversity has pushed for a better protection of inland water ecosystems. But if you look, for example, on the site of the IUC and the International Union for the Conservation of Nature, which is a very important institution, you will see that there are signals, there are reports about the fact that a lot of these inland water ecosystems are destroyed and that we should do something to protect them. Other conventions which are worth mentioning, the 94 Convention to Combat Drought and Desertification. I don't need to explain the relationship between rain and clouds and droughts and so on, and desertification. The same with the instruments in relation to climate change. If you want to, the carbon sinks, the fact that adaptation is becoming very important. And when we speak of adaptation, you have to think about floods and so on, which are the cause of severe impacts. But if you think about climate change, you also think about energy, hydroenergy, and so on. So there are a lot of links that to be established between these conventions and the protection of fresh water. Now, what I think the value added to these conventions, in addition to the fact that they are sort of developing a new way of looking at fresh waters, is that all these institutions have institutions. They have institutions, they have established conferences of the parties, they have secretariats, and they also have compliance mechanisms, compliance and compliance mechanisms. And remember what I said about the 97 Convention. Dispute settlement is not well developed. So it's just to show you that, in fact, when thinking about how to protect better an international water course or another source of water, an international aquifer, one can also refer to international environmental conventions and look at the dispute settlement mechanisms and the compliance mechanisms. And I've given you an example of a dispute that opposed Romania to Ukraine that was brought before the Aarhus Convention dealing with public participation and the ESPO Convention, which is dealing with transboundary impact assessments. So that's the pillar about environment. And very often, and I will finish with that, but very often if you look at the basin agreements, you will see that the provisions dealing with environmental protection are not well developed. So one way to think about how to protect better the environment of fresh water is to develop these provisions. But I do feel that interpretation is also very important. So you should interpret these provisions in light of the multilateral environmental agreements. And if you've looked at the cases brought before the court, so Uruguay, Argentina, Uruguay, but also Costa Rica, Nicaragua, and so on, you will see that, in fact, the court is more and more open for this new way of interpreting provisions of treaties which were concluded when the environment was not yet an important topic of negotiations. Now we move to the last subject that I'd like to discuss with you, which is water, environment, and human rights. And as I said, traditionally, international law was not really, when speaking about water, was not really looking at the people as such. Traditionally, international law was saying, you state, you should discuss with the other state because you have something in common and you're entitled to certain rights of access to this water. But very rarely would you have regulations and treaties which would say, look, you can have access to this water, but this access is also conditioned by the access that people should have, you know, and that you should also take into account what the people are deserving in terms of human needs, and you should also take care about their essential needs and so on. So what that I'd like to speak with you about is the fact that international water law has different ways of looking at the regulation, but I do feel that this last part, this relationship between water, environment, and human needs is very important because it's a way to make all states of the world, I'm speaking of all states of the world, it's a way to make them accountable to the people, okay? It's a way to make them accountable to the people and to say, you can play power muscles with respect to, you know, access to water and quantities, but at the end of the day, what is important is to know what you're doing with this water and do the people have access to this water as they should have access to. So we're going to be looking at this, and I've already spoken about this this notion, but I consider that we can speak of a right to water. For a long time, I spoke about an emerging right to water. It seems to me that it has now become an effective human right as such. Now, how to relate to this water? No need to remind you that without water, we can't survive. And air and water are two natural resources that are essential for all the human beings. Now, I've put you figures just to show you that there are great disparities, and that we still have 1 million people who do not have access to safe water, and we have more than 2 billion who do not have access to adequate sanitation. And sanitation is often also forgotten. We need adequate sanitation if we want not to have the spreading of diseases and pandemics. I don't need to speak about COVID-19. We all are facing this challenge, and we all know that if we want to prevent the spreading of the pandemic, access to water is fundamental. Now, what is interesting for us is that these figures are coming from reports of the Agenda 2030, which is sort of specifying what we call the Sustainable Development Goals. The Sustainable Development Goals, it's a resolution of it was in Rio and in the aftermath of the meeting of 2012. And there they discussed the agenda, which was to be put in place for as from 2015, saying we need targets, we need indicators. We can speak of rights, but we also need to have indicators, and we need to be sure that everybody is going to have access to water by 2030. So if you're interested in these figures and what are the figures in terms of unequal access and so on, look at the reports of the United Nations with respect to the Sustainable Development Goals. What I'd like to stress in this context, and it's not on the PowerPoint, is that among the Sustainable Development Goals, we have one, which is Sustainable Development Goal 6, okay? 6, and Sustainable Development Goal 6 is saying all human beings should have access to safe water and sanitation and adequate sanitation by 2030. And when you look more carefully about the way SDG 6.1 has been drafted, you see that in fact, SDG 6 is a reflection of the human right to water and sanitation. Okay, so when the states committed to the fulfillment of the SDGs, this was a resolution adopted by the General Assembly without any opposition by all states of the international community. They all accepted that there was an entitlement for each human being to have access to safe water and adequate sanitation. I'm stressing this because I think that this was a major step for acknowledging the right to water. And what is important is now to push for the acknowledgement in effective terms of this human right. So how was it sort of formulated before SDG 6? I've just mentioned in the PowerPoint that you have a very important comment number 15 of the Committee on Economic, Social and Cultural Rights of the which was established in the context of the Covenant of Economic on the Protection of Economic, Social and Cultural Rights, which said, in fact, when we speak of Article 11 and 12, adequate housing and so on, we are also speaking of a human right to water, which entitles everyone to sufficient, safe, acceptable, physical accessible and affordable water for personal and domestic uses. This is very important for those interested in international economic law, because you know that you have a lot of investment disputes in relation to water concessions and so on, where the states are saying, I respect the law of investment, but I'd consider that there are arguments made in relation to human rights that should be respected by states, but also by private companies when they are negotiating contracts and so on. So, and when they are speaking of the right to water, they're referring to this definition. And in fact, if you look at other instruments, you will see that you have a resolution of the General Assembly of 2010, which is also speaking of the right to water. In the context of the General Assembly resolution, it was Bolivia which pushed, which was at the forefront for this, the adoption of this resolution. And Bolivia said it's more than, linked to other human rights. It's the mother of all human rights. So you will see this type of formulation in the resolution of the General Assembly. And then you have also a resolution of the Human Rights Council, which sort of reflected what the Committee on Economic, Social and Cultural Rights had said. Now, to just a few words about when you speak of a human right to water, what does it mean? It means that there are obligations for the states, for each state of the international community, in terms of in terms of treaty law, but also I think in terms of customary international law. Respect, protect, and fulfill. Fulfill is very important. It requires from all states to take positive measures to assist individuals and communities to enjoy the right. Now, speaking from a Western country perspective and speaking from the perspective of Switzerland and France, and binational of these two countries, you think about nomadic populations in Europe. And when you look at the treatment of these populations in Europe, the Roms, for example, you realize that some of them don't have an access to water, don't have an adequate access to sanitation and so on. So all that is to show that it's something that should be respected, fulfilled by all states of the world. But the issue that I'd like to stress is this issue of positive measures, proactive measures to make sure that all individuals and communities will enjoy this right. Now, to conclude with this presentation, I'd like to mention a very important decision that was rendered by the Inter-American Court of Human Rights in very recently, and there is a mistake. It's not 6 February, but it's 2 April 2020, so you can correct that on the, and it's about the protection of indigenous populations in Argentina. It's about land demarcation, the non-respect of land demarcation, the fact that some other communities would access to the water on these lands, and they would pollute the water, or they would deprive the populations from the water of the sources located on these lands, and so on. And there, it's very important because the Inter-American Commission said there is a need to respect the rights of the indigenous populations, their right to a healthy environment. And when they spoke of a healthy environment, which is not explicitly provided, as you know, in the Inter-American Convention on Human Rights, but the Inter-American Court of Human Rights said, in fact, we have a provision which entitles us to progressively develop the content of human rights. And it says there is now a right to a healthy environment, as the court had said in its advisory opinion of 2018. And it said, and the right to a healthy environment means that there should be also access to water for the indigenous populations. So this is a major step, I think, in Latin America, and I'm sure that it's going to have resonance in other regions of the world, because when we speak about the right to environment, we will be able to link it to access to water. But I think that already, even, and at the last point, even if we don't yet have many decisions, I think that the multilateral environmental agreements, the human rights, the comments, and so on, showed us that you can't speak about the environment without speaking of water. And you can't speak about water without speaking about the environment and the access, protection of the environment. And I'd like to give the example of a comment that was adopted by the Committee on Human Rights last year on the right to life. And there is stress put on the fact that without adequate protection of the environment, the right to life is not going to be well protected. But if you could also use this to say, without adequate protection of the water, the right to life is not going to be protected. So it all shows you that there's been a major development in terms of international law with respect to what is classical international water law. But I feel I'd like to stress that, in fact, we should look at this body of law, but we should complement it with other bodies of law, such as environmental law and human rights law. And I don't have much time to go to other bodies of law, but you could speak of humanitarian law, or international criminal law, and you will see that there are links which can be made. So with that, I'd like to thank you for your attention, and I'm looking forward to exchanging with you about this important topic. Thank you very much.
Thank you very much, Professor, for your brilliant lecture. I think was very clarifying for us all. And I think we can move already to the questions. We have quite a few questions here. So let me just get at the first question. Igor, he would like to ask you if you could comment on the international controversy between Chile and Bolivia. You mentioned about Silala watercourse that is now on the ICJ.
So there's a disclaimer that I didn't do that I should have done. So I was a counsel with Argentina in the pulp mills case, and I'm a counsel with Chile in the Silala case. Okay, so I think for me, and it's the only thing I'm going to say, is that what is interesting with the Silala case is that there you don't have any treaty. There is no bilateral treaty between Chile and Bolivia. So this is a case which will be resolved in accordance with customary international law. Okay. And if you look at the case law of the International Court of Justice with respect to water disputes, it will be really the first time that, there is no treaty to which the court can look at while interpreting it in light of contemporary international law. There, the court will have to look at what is customary international law and what is the practice of both states and so on. So I think it will be interesting for scholars of international law.
Great, thank you, Professor. Another question here from Elena, and she wants to know what's your opinion, if it's possible. Okay, I think you answered that. If it's possible to affirm the existence of a human right to water. I think you explained that in your lecture.
Maybe I could come back to that, because maybe you can consider that I'm a bit too doctrinal. Okay, maybe that you can say, but look, Professor, you're just like quoting texts and so on. For me, I would say that maybe I had some uncertainties when we were only looking at the general commentary of the Committee on Economic, Social and Cultural Rights, and when we were only looking at, we had only the General Assembly resolution or the resolution of the Human Rights Council. Now, for me, the SDGs resolution of 2014 is fundamental, because there was a step which was made where all states said, what we want in effective terms is that all individuals have access to water. And the other thing which I think is very interesting with the SDGs is that in human rights terms, when you speak about the right to water, very often, you forget that in fact it's a right to water for domestic users. So for household perspective needs, and for food needs and cooking and for bathing needs and sanitation, it's to be able to have an adequate sanitation system so to prevent the spreading of diseases. Now, the SDGs and the agreement of all states, I speak of an agreement because nobody opposed it, okay? The agreement is that SDG 6.1 says, in hospitals, in schools, in other infrastructures, access to water should be made for all individuals. And I think that is very important because, for example, school and access to water, this is crucial and so on. But let's speak about other places where we often forget them, but jail, prisons, okay? Prisons, and you have cases before the Inter-American Commission about access to water for prisoners. Yeah, it's a sanction, but we should treat them in dignity. And there it was often forgotten that they should be provided with water and so on. So it's just to show you that, in fact, there is also an acceptance to broaden the scope of the human right to water. And that, I think, is very important. Now, there we have, it's the narrative, it's the discourse. If you look at the figures I've given them to you, I've looked at the figures of this year, we are far from the fulfillment of this goal. But at least we have this common language and we have this acceptance that we all committed to fulfill this goal. And I think that is very important.
Great, thank you, Professor. Okay, the next question is from Nicholas. He said, desalination, okay, there you go. Desalination seems to be a viable resource to solve water scarcity in parts of the world. But what's international law's view about its environmental impacts, such as brine ejection in the ocean?
Yeah, that's a good question. We have specialists here. When we speak about the water, where I come from, the water cycle, okay? We always have the same quantity of water on Earth, okay, but in different stages. Now, are there ways to produce water? Desalination, okay? Fresh water. Some countries have experimented that. Think about Singapore, Israel, some Arabic countries. It's very expensive, okay? It's very expensive. And then there are environment impacts. Okay? So they have also to be looked at and faced. And I'm not so sure that we still yet have the technology for preventing these environment impacts. But I think that when we speak about desalinization, it might be resorted to if we prevent environmental damages, if we have the right technology and so on. But we're going to be using energy. So which kind of energy are we going to be using? That's another question with respect to climate change. And then it's always going to be in a very small amount. So for me, desalinization, in a way, we should deal with that. International law is looking for the time being mostly at the environment impacts, nothing else, but it's not the solution for all the problems of scarcity. Really, the problems of scarcity have to be faced with the water that we have, with the sources that we have. And I think one way also is that we all waste water, and we have to find ways to waste less water. And recycle water. And you have countries in the world where, in fact, they are recycling the water. And they are even drinking the water which is recycled. So we also can do that. Yes, thank you.
Okay, one other question from Fernando. He said the cases on transnational watercourses and the limitation of maritime boundaries before the ICJ have some striking similarities in the application of equity. The latter, however, seem to pay less regard to environmental law. Do you think this is due to the nature of the dispute, or is there space for more interplay between those two categories of cases?
This could be a topic of a dissertation. I think it's an excellent question. I'm not going to be able to, when it's boundary delimitation. What I'd like to refer is to what happened in the South China case between the Philippines and China. Okay, so there, it's not a question of it was in a way it was not an issue of delimitation per se, but there were rights to be identified. But what I think is interesting in this case, the tribunal had to look at environmental protection and the need to protect certain species and so on. So it was one of the first awards where the law of the sea was sort of linked in a very close manner with environmental protection and so on. Now, there might be other issues, and I'm not so sure that environment per se can sort of, but you can contradict me and we can continue the discussion, that environment per se should be taken as a factor for tracing the boundary. Okay? But that said, for fresh waters, think about the recent decision of the International Court of Justice in the Burkina Faso, Niger. I think it's, Burkina Faso, Niger. There was, we should check, it's the one of 2013. Burkina Faso, you will have to check. There was a water course which there was a need for tracing the boundary, and the court said, I'm going to take into account the access to water of the population to be able to trace the boundary. But that is an exception. This put aside, I think that more and more, even if you have the boundary for the the exclusive economic zone or for the continental shelves and so on, or the outer continental shelf, you will need to also think about how to better protect the environment, which is in fact shared by the countries which are riparian in a way or another. And you know that the fish, they don't care about, they don't have a nationality, these fish. They just like navigate cross from one space to another. So my take on this question is that the law of the sea already have part 12 dealing with the protection of the environment, but I think there's, and the Philippines-China case has shown us that there is a path to be taken for integrating environmental protection. But I think that there is more to be done with, and to be made, and more efforts to be accomplished.
Perfect. Thank you. Okay. Gabriela would like to know how you see the international view of the environment itself as a priority when access to water is denied to people, implicating in future international crises such as COVID.
COVID. It's for me, I think it may, in Europe, we are going through this crisis. In Brazil, I know that you're going through this crisis. In other countries too, it's a shared crisis, and we should show solidarity. And that's the first thing I'd like to say. Okay, but something, and I'll tell you a story. I had to make a presentation at the meeting of the American Society of International Law and Development. And I chose to take SDG 6 on water, law and development. One thing I realized, and this was very interesting, is that, so it makes sense to have access to water, because if you want to protect health, you need access to water. And we are told that everywhere, okay? You have to. But then I looked at the indicators, okay? How to make sure that people have access to water. What was interesting is that we don't yet have an indicator on hand washing facilities. This is something which is absent from the Agenda 2030. We have a mention of it in passing in the SDGs on the right to health, but in terms of water, this would make sense. So that made me think a lot about, we still have to make progress about to show how water is so important for health, for education, for human needs, and so on. And I'm sure that this crisis is going to bring us back to reality. And I hope that it's going to create an impetus for doing more efforts, taking more proactive measures, so that we can better protect and ensure the right to water.
Okay. Isabel is saying here, when we consider poor countries that would have no means of effectively implement the international resolution, how could the international community actually assist them?
Fair question. Let me start with the fact that I think that when we looked at the obligations of states, all states of the world have an obligation to fulfill the human needs of their population. Okay? So the states is going to be the key actor for selecting, deciding about the best measures so that all individuals have access to water and sanitation. But then comes an issue of resources, being knowledge, resources or financial resources. And there I do feel that there is an international obligation of cooperation among states. And in this context, I think that what we have seen, for example, with some of the saying of some of the financial institutions that there should be, for example, COVID measures, programs put in place, I'm sure that a lot of them are going to be targeting the need to provide access to water to the population, access to sanitation, and so on. So, and that is sort of grounded in what I call a meta obligation because of cooperation. But then, more specifically, if you look at the Covenant on Economic, Social, and Cultural Rights, and you have authors like Philip Alston who has written about that, I think that in Article 2 of the Covenant on Economic, Social, and Cultural Rights, you have the obligation of international cooperation. And I think that states should not forget their obligation to do something, so to help other states to be able to ensure respect for economic, social, and cultural rights. So it can be done through bilateral assistance and aid, but it also can be done through multilateral channels. be it international institutions or financial or developing financial, the World Bank or other financial institutions.
Thank you, Professor. Okay, we have another one here from Osvaldo. Said the 1997 convention is widely considered as reflecting principles of customary international law. In your opinion, would it be the same case for the draft articles on transboundary aquifers?
Good question. Good question. And I'm going to say I'm not sure. I'm not sure. I think that at least we can say that there is an agreement on the principle of the basic principles in terms of access, that there should be reasonable and equitable access, and there should be an obligation not to cause a significant damage. Okay. But those are principles of the general nature, and then comes the issue of the negotiation between the riparian states and so on. With respect to the vulnerability of aquifers, I'm not so sure that we have yet sort of crystallized these provisions dealing with the fact that a lot of these aquifers are not going to be easily rechargeable. And so, and then we also know that there is great sensitivity to pollution for a lot of these aquifers. So there, I would like to think that we can speak of a principle of customary international law. I'm uncertain, and then I'm uncertain too about the role of the precautionary principle and the management of aquifers. And when you look at the state practice, this is also something which is that they are quite reluctant to negotiate instruments, and I'm not so sure that the principles of customary law are sufficient for managing well a transboundary aquifer. So work to be done.
Oh, perfect. Thank you. Okay, let's move to the next question. It's from Ana Clara. And she said, considering the last report of the UN Special Rapporteur on Poverty and Human Rights, Philip Alston, could you comment the current trend of privatization of water provisions worldwide? Sorry.
Yeah. So I have not, disclaimer, I have not read this report. So I had worked a lot on the reports of Catarina de Albuquerque. Okay, and I think I'm in line with what she says in a way that, and maybe you're not going to agree with me. For me, access to water is important for all individuals. And I'm not sure that the access to water is important, but I'm not sure that we should only have public money for that. And I think that private money can play a role. If you look at the figures of the SDGs, you will see that without private money, nothing is going really to be done, because you need this private investments. Okay. So in a way, I think I would be sort of neutral with respect to the source of the money. But in both cases, what I think is that when we speak about investment in the field of water, we should make sure that it complies, they comply with the criteria of the human rights. So I'm looking at my note, but remember, the human right to water entitles everyone to sufficient, safe, acceptable, physically accessible, and affordable water. Affordable water, that's the big thing, is that what should be the price of the service. And there, what we see is that, and we're speaking about it in France, for example, is that we have to take into account the level of income of the people. Not everybody is able to pay the same price of water. So what I've seen is that in some water concessions, there have been some differentiation in terms of prices and so on. In France, they're also speaking about this, saying that there are people who should pay more, and there are people less, and so on. Maybe. So that's one way. But what is sure is that even if you don't have any differentiation, if you ask someone to pay for the water, it should be affordable. And that is something to be taken into account, taking into account the resources of the people in question. So that's one thing. Now, safe health is fundamental. So there are obligations for the water, for the investors and so on. And you have some investment decisions which are interesting because they are now. And you have a quite recent one dealing with Argentina, which was saying, but the right to water should be fulfilled by states, but private companies, don't they also have obligations? Question mark. Okay. Shouldn't they also respect the right to water? What I think is that at least there is an obligation of due diligence. They should not impede, they should not prevent the satisfaction of the right to water. But that's all what I can say about this because I have not yet read the report of Philip Alston. Yeah. But okay. I think if you think about the reports of, I don't know if it's the report dealing with the United States or the one dealing with the UK, because he's been very brave, Philip Alston. He's done magnificent reports, and the other one dealing with the Haiti crisis. You see that there are problems everywhere in the world. It's not just an issue of southern countries. The northern countries have a lot to do.
Yeah, it's interesting that you mentioned because there's in the cases studied by Professor Morgan, in her book, Water on Tap, all the places that went through a similar process relating to the private participation in the sector face significant social conflicts. So yeah. It's right all around. It's not just a particularity of the south countries. Okay, the next question. Just a second. Okay, Renata is asking, what happens when a company commits a damage to the right of water? Are there any international provisions or obligations?
That's, Renata, I'm not going to be able to give you a clear answer. What I think is that, when there we are speaking about international law, okay? What I think is that if you really want to strengthen this access to water and sort of reflect what is in the norms of international law, we have to strengthen domestic law. Domestic law is crucial. Domestic law is crucial because it's there, it's reflected. And then for states, it's easier to have then a discussion and to resolve a controversy with the private investor or public investor, because domestic law will find application in a way or another. Okay. And so I think that for me, when we speak of human rights, it's very important to be thinking about the domestic legislation and the domestic mechanisms for ensuring respect for human rights. Now, speaking about investment law, there have been some attempts, but for the time being, they have not been very successful. I think one attempt, and it might be something interesting for you to look at, it's counterclaims, states bringing counterclaims against investors and saying you've not abided to law, to domestic law, to international law. But the problem for us is that what does international law say about the obligations of the private actors? So it's room for thought for the young generation.
Well, thank you, Professor. One last question here. Fernando is asking how forecast-based financing or measures to prevent water shortages can be or are done by international organizations, and how could this be a human rights action on developing countries?
So what I see is that I think UNEP, the United Nations Environmental Programme, is more and more sort of developing its discourse about water. UNDP is doing a lot of efforts, the World Bank, and so on. So I think there is a common acceptance that it's one of the priority in terms of development. There is then a need to from the human rights perspective, I think that I'm all in favor of developing this right. I think that this right will be very important at the domestic level. I also think that we didn't discuss that, but I think we should also develop it from a constitutional law perspective. Not many countries have done that so far. Some have done it, but not many countries. So you have this possibility, but human rights mechanisms, they're always going to remain sort of limited in their ambit because it's a case-based approach. So I think that it's really, we have to engage with the development agenda, and that's where we might be more successful. But human rights is offering something that I mentioned earlier, which is the accountability, because all states are accountable. So they can't say that it's domestic affairs. It's no more domestic affairs. It's international affairs.
Oh, perfect. I think we have time for one more, Professor, and I have a question. Well, both cases that you mentioned are examples of decisions that help to establish the concept of sustainable development. That shows that water is related directly to the dimensions of sustainable development. And you've approached in one of your books the economical, environmental, and humane dimensions of the law applicable to water. And there's a question in J. Ellis' work that is a simple and a recurrent one, but I think it's an important one if we consider the decentralization of international law. Could regimes that are devoted to the pursuit of one type of objective, say fostering trade liberalization, be trusted to pursue other objectives, environmental and human rights protection? In other words, do you think the institutions of international trade, for example, could contribute effectively to issues of access to water?
Trade it's another issue because if you've seen, I don't think that water is a good as, as you can think about, I don't know, a bottle of milk or, it's, so bottled water maybe, okay? Bottled water, but then we should also question the origin of the water in these bottles, but that's another issue. But then when it's water in its natural status, I don't think that it's covered by the regime of the trade law regime. I don't think. And what we've seen so far is that in the context of the regulations, the regional free trade agreements negotiated by Canada. Canada has made sure to exclude the fresh water from the ambit of the trade regimes. It's done that in the context of its relationship with the United States and Mexico, and it's done that in the CETA, in its relationship with Europe. I think that other countries would accept this idea. What I want to say is that maybe a state can sell water, and we have some examples. The example you read quite often is Turkey selling water to Israel, or is Singapore buying water from Malaysia, and so on. Those are specific agreements. I don't know if they are. I'm not going to speak about the legality of these agreements, but from a general standpoint, I would say that at least from the perspective of international law, I don't think there is an obligation on states to export their water. I don't think we can speak about that. And I think that if they export that, there are conditions, environmental conditions that should be respected and so on. So I hope that we can exclude fresh water from the ambit of the resumption of WTO, if it's made alive after all the discussions.
Thank you very much, Professor. Well, unfortunately, that's all the time we have. So I'd like to thank you very much. It was a wonderful time here. I'm sure everybody at home has learned and enjoyed as much as I did.
So it was a pleasure to be with you. And I'm very frustrated not to see you all. Thank you very much. Bye-bye.
Thank you. Bye.